I am a university at the Professor School of Law. I teach at the University of Montana School of Law, and I'm honored to welcome all of you here today. We will be hearing arguments in front of the Montana Supreme Court. I'm going to introduce the case to you so that as far as possible, you'll be able to have a general understanding of what these guys are talking about when they're up here today. I especially want to welcome those of you who are attending a Supreme Court argument for the first time. For many years now, the court has held arguments in various cities and towns across the state of Montana so that people like yourselves have a chance to see how our legal system operates and hear how lawyers and judges work. You may have noticed that I referred to the event today as an argument. We call them arguments because each of the lawyers who's going to be up here is trying to convince the justices who will be sitting behind me that his interpretation of the law is the correct one. And in the law, we call that arguing. I can almost guarantee, just in case you're wondering, that none of these guys will be shouting. I don't know how many of you know this, but every court in this country is open to the public. Courts are considered the people's place, and you have a right to attend any hearing, trial, or argument that's being conducted there. If you are ever in Helena when the Supreme Court is holding oral argument, you are always welcome to attend. I'd like to begin with a short overview of the Montana court system before discussing the case that's going to be heard today. The Montana Supreme Court is the state's highest court. It's the only court of appeals that we have in the state of Montana. We have district courts, we have justice and municipal courts, but once someone wants to appeal, the only court to which they can go is the Montana Supreme Court. Our court has 7 justices on it, although today only 6 will be here. We have 1 Chief Justice and 6 associates. The Chief Justice is Carla Gray. The Associate Justices, in order of seniority, are Bill Leapart, Patricia Cotter, nope, that's not right, Bill Leapart, Jim Nelson, Patricia Cotter, Jim Rice, John Warner, and Brian Morris. Justice Nelson is not here today. Chief Justice Gray will sit in the middle of the table, in case those of you are wondering which one is the Chief Justice. For the next few hours, this auditorium is, in effect, a courtroom. So I need to say a few words about courtroom etiquette. After my introduction, and we turn the podium around, the clerk of the court will call court, that's what we call it. And the justices will enter into the auditorium up on the stage, and all of us will have to stand. And we will remain standing until the Chief Justice tells us that we can sit. Being in court is not unlike being in church. We have to sit, we have to stand, we have to be quiet, which means it's a really good time right now to check your cell phone and make sure that it's either turned off or put on to silent. I will check mine. That would be really embarrassing. The case that we are hearing today is called Oberson versus the United States. This case is unusual in the way that it's being presented to the Supreme Court. It actually began in federal district court. In the state of Montana, as everywhere, we have both state courts and federal courts, and for the most part, those two systems operate independently of one another. Every now and then, though, the federal court stops and asks the state court what the proper law of the state is. And that's what's happening here today. The Federal Appeals Court has asked the state Supreme Court 3 questions. I'm going to tell you what those questions are just so you start hearing the words, and then I'll try to explain a little bit better what they mean as we go on. The first question that the federal court has asked is whether the gross negligence standard of care in the snowmobile area statute violates the equal protection guarantee of the Montana Constitution. That's the first question. The second question is, if the gross negligence standard of care is unconstitutional, then does the willful and wanton misconduct standard of care from the recreational use statute apply in its place? And finally, if neither one of those standards of care applies, does the duty of ordinary care apply? The party to whom the standard of care applies in this case is the Forest Service, the United States. So we are trying to determine in the case that I'm going to tell you more about here in a minute what standard of care we're going to hold the Forest Service to in the case before it. The plaintiff in this case is a man by the name of Brian Musselman. The reason the case doesn't have his name on it is because his sister is his guardian and her name is Lori Oberson, so that's how we get Oberson. But Brian Musselman is the person who was injured in this case. He was severely brain injured in a snowmobiling accident in 1996, 11 years ago. And the second plaintiff is his daughter, Devin. Devin was not injured in the snowmobiling accident. Her injury was the loss of her father to this severe accident. Although he didn't die, he was injured severely enough that he's unable, essentially, to speak or move. He can communicate only very basically. Now, the story of what happened in this case is no longer in dispute. And that's because those facts were decided by the district court when it held a trial back in 2002. And on appeal, those facts were not challenged, and the only question we have left is this question of law that's being addressed today. So here's the story as the district court found it. Brian and some of his buddies came to West Yellowstone in 1996 to go snowmobiling. They lived in Michigan. They came out to West Yellowstone for a few days. They snowmobiled for a few days in the park, and a few nights into their trip, they went to dinner, they ate, they drank, and then the 4 guys got on their snowmobiles to ride back to their hotel. To get there, they went down a trail that none of them had yet been on. It's about 10 o'clock at night, so it's dark, it's February or January, but it's winter, it's dark. They haven't been on the trail, and they've been drinking, some of them more than the others. Brian was the first snowmobiler. He came over the crest of a hill, and the way the hill is described, which is an important part of the case here, is a 17-foot drop over 80 feet, which is translated into a 25% slope, relatively steep. But the way it's also described is that when you're coming straight up to it, it's not visible. You can't see that you're about to come over a hill. That's a key fact in this case. So as Brian approaches the hill, he goes over it. He lands safely at the bottom. The second guy comes up. He goes over the hill. He describes feeling like the bottom dropped out. He crashed at the bottom but didn't fall off of his snowmobile. At that moment, or thereabouts, Brian got off of his snowmobile and began walking back across the trail. And we don't know why. Was it to go help the other guy, or we don't know. And then the 2 remaining guys who were found to have been drunk and who were found to have been racing one another and were going 50 to 55 miles an hour came over the top of the hill, and one of them ran into Brian, came down the hill, and the snowmobile hit Brian in the head. He was wearing a snowmobile helmet, but that wasn't enough to withstand the impact. And that's what caused his severe injuries. Brian sued the United States Forest Service for negligence in maintaining the snowmobile trail. He argued that the trail was unsafe because the hill was so steep, and said that the Forest Service should have had a sign warning the snowmobilers that the hill was approaching. The trial was held, as I said, in 2002, so 5 years ago. It was a bench trial, which means that there was no jury. The judge was the finder of fact, as well as the person who made legal conclusions. The Forest Service brought into the case the 3 other snowmobilers. So there were 4 parties, 4 defendants, plus Brian. The judge issued his opinion in 2004 and found that the Forest Service was negligent for failing to warn of the hill. He found that the 2 snowmobilers who were drunk and racing their snowmobiles were negligent. And he found that Brian was negligent for getting off of his snowmobile and walking back across the trail. Under Montana law, once you find that there's more than one guilty party, the court needs, or the jury needs to determine what percentages we're going to make each one of them liable. And in this case, the court found that the 2 snowmobilers were 50% liable and that they acted so much together that they're jointly liable for that 50%. The Forest Service was 40%, and Brian was 10%. Then the court found the exact amount of Brian's damages, and it was a big number. This is not punitive damages. These are compensatory damages, meaning these are the damages that the court found would compensate Brian for the economic and non-economic losses that he suffered as a result of this accident. The final number added up was a little over $11 million. Then the court takes away Brian's 10%, and then the Forest Service is liable for its 40%, and that number was a little over $4.5 million. There's a lot of money at stake here. Everything I've told you about so far was decided by the district court. Once a case is decided at the district court level, it can then be appealed. In the federal system in Montana, cases are appealed to the Ninth Circuit. The U.S. Supreme Court is the court highest after that. In this case, the Ninth Circuit affirmed the district court in all regards except one, which is why we're here today. Sometimes, as I mentioned earlier, a federal court says, we don't really know what the state law is in this regard. And so, state court, we would like you to tell us what it is. We call that process certifying a question. I think I mentioned that earlier, and that's why we're here today. This is a negligence case, as I mentioned, and in negligence law, we apply what's called a standard of care. Negligence law says basically that we all are required to act with a certain level of care, and if we don't, and someone is injured as a result, we have to pay for their injuries. Generally, that standard of care is what we call an ordinary standard of care, or reasonable standard of care. You have to act as a reasonable person would act under the circumstances. Now we get to what we call statutes. Statutes are the laws that are enacted by the state legislature, and they're relevant here because that's where the standard of care may come from in this case. In 1987, the Montana legislature enacted the Snowmobile Area Statute. And that statute says that a snowmobile area operator, which would include the Forest Service, is liable for someone else's injuries only if the operator, the Forest Service, is grossly negligent. What is gross negligence? Good question. There is no precise definition. You don't have to be as careful as you do if you're exercising a reasonable level of care. So, for instance, if a reasonable care standard would be taking the precautions that a reasonable person would take in the same situation, such as warning someone that a steep hill is approaching, a gross negligence standard would be taking the precautions that someone who wasn't having to be as careful would take. It probably would not include warning of an upcoming hill, but we don't know that for sure either. The federal district court, before it ever got to trial, decided what standard of care it was going to apply. And it did that because the lawyers argued which standard of care they thought should apply. The district court looked at the snowmobile area statute. It looked at an earlier case, which you may hear mentioned today, called Brewer, which isn't about snowmobiles, it's about ski areas. And it looked at that case, and it looked at a case that the federal district court had also decided regarding the snowmobile standard of care. It put all those things together, and the federal district court decided that the gross negligence standard was unconstitutional under the Montana Constitution because it violated, I think it cited on equal protection grounds, I'm not even sure about that part. It decided it was unconstitutional. I'm assuming it was because of equal protection. I don't know that. But it did so as a federal court, not as a state court. And that, again, is one of the keys here. So when the Ninth Circuit got this case, it looked at that decision and it said, I think we need to find out more about this because it is so key. And I think rather than our federal system deciding what the standard of care would be under Montana law, we should ask Montana what it thinks. As I mentioned, the first question today is whether the gross negligence standard in the snowmobile area statute violates the constitutional guarantee of equal protection. Our state constitution, we have both state constitutions and federal, our state constitution says no person shall be denied equal protection of the laws. In order to challenge a law on equal protection grounds, a party, and in this case the plaintiff is challenging the constitutionality of that statute, must first show that the statute classifies people into different groups and then treats people who are essentially in the same group differently. You're allowed to treat different people differently. But if people are similarly situated, that's the phrase you'll hear. If people are similarly situated, then you need to treat them equally. So as you can imagine, one of the things that will be argued here today is who we use to determine similarly situated. What group are we going to compare snowmobilers against? The plaintiff will argue that the group against whom we must compare is people who participate in other inherently risky sports. And the plaintiff will point out other statutes that have been passed by the Montana legislature regarding those kinds of risky sports, such as skiing, horseback riding, outfitting, and the plaintiff will say none of those statutes relieves the operator of his or her duty of ordinary care and says they are liable only if grossly negligent. The government, not surprisingly, will have a different argument. The government will argue that snowmobilers are compared to snowmobilers, that the legislature has the authority to treat snowmobilers differently than skiers and differently than horseback riders because the sports themselves are different and because one of the purposes, stated purposes, of the snowmobile statute was to protect the snowmobiling industry from lawsuits. And the government will argue that that falls under what we would call economic legislation, where a state is deciding things that have to do with its own economy, with money. And it will say that courts are very reluctant to mess around with a state legislature's determination through economic legislation. Now, an equal protection challenge includes a second step. If it is found that a statute treats similarly situated individuals differently, that doesn't mean that it's over yet, because the legislature is allowed to treat even similarly situated individuals differently as long as it has a legitimate purpose for doing so. And at this point, the courts use a test. Courts often like to use tests to determine the outcome of a case, how they're going to analyze it. The most commonly used test in equal protection analysis is called the rational basis test. And what it asks is whether the classification, the treatment of some similarly situated individuals differently than others, is rationally related to a legitimate governmental purpose. There are other tests that are used. Strict scrutiny is used when the plaintiff argues that a fundamental right of his has been infringed. So, for instance, racial classifications are subject to strict scrutiny because we have a fundamental right not to be treated differently because of our race. In Montana, the court has now and again applied what's called an intermediate level of scrutiny. Falls somewhere in between rational basis and strict scrutiny. The plaintiffs will be arguing for a higher level of scrutiny. And in order to do that, the plaintiffs have to identify a fundamental right that's being infringed by the classification. And what the plaintiffs are pointing at comes out of Article 2 of the Montana Constitution, Section 3, which makes reference to a fundamental right of safety. This is not something that's ever been decided by the Montana Supreme Court before. So the plaintiffs are arguing that a fundamental right of safety is affected by the standard of care and the differentiation between snowmobilers and other sports, and that the court should therefore apply a higher level of scrutiny, either intermediate or strict scrutiny. So you're going to hear some of those words thrown about. Once the court decides if the gross negligence standard is constitutional or not, if it decides that it is constitutional, then we don't need to go on with the additional certified questions. But of course, all three questions are going to be argued here today. And the second question is, okay, let's say you find out that the gross negligence standard actually is unconstitutional. Then what? Now, the Montana Federal Court answered that question by saying, well, then it's the duty of ordinary care. It's the duty that we all apply, or that we all owe to each other all the time. For a number of reasons, it made that decision. But the government is arguing that there's another statute that should apply, and that is called the Recreational Use Statute. Now, this statute was enacted in 1965 by the Montana legislature, and it says this: if a landowner allows people to come onto his or her land to recreate and doesn't charge them any money, then if one of those people is hurt, the landowner is liable, in other words, has to pay them for their damages, only if the landowner engaged in willful or wanton misconduct. So this is our other standard. We've had ordinary care, we have gross negligence, now we have willful and wanton. And those words alone, I think, can probably signal to you that we mean pretty awful. It's short of intentional conduct. So if you took a baseball bat and hit somebody when they came on your land, that's intentional harm. We're not talking about that. We're talking about something less than that. So it's more negligent than gross negligence, but not as much as intentional. So we have this entire spectrum here. The government argues if you take away the gross negligence standard in the snowmobile statute, then you go to the recreational use statute, then it's an even, depending on how you look at it, higher or lower standard of care. And we still did not have any duty to warn Brian Musselman of that hill. The third question is, if neither of those statutes apply, does the duty of ordinary care apply? It's worth noting here that the snowmobile area statute was amended in 1999 by the Montana legislature, and that amendment took out the gross negligence standard of care. The statute no longer limits liability to an area operator's gross negligence. That statute was not in effect in 1996. The government has argued that it's not retroactive, and plaintiffs haven't directly addressed that argument to my knowledge. So the 1996 statute is what we're looking at, even though it is no longer in effect. The end result of what happens today will be a written opinion by the Montana Supreme Court that will answer these three questions. If the Supreme Court holds that either the gross negligence standard or the willful and wanton misconduct standard apply, the Ninth Circuit has already said the case must then go back to the district court to be retried. If the Supreme Court holds that the ordinary care standard applies, then the district court decision will be affirmed and the government will be required to pay Brian Musselman the amount of money that the court determined it owes him. In a few minutes, you will hear the argument begin. On my right and your left are the government lawyers, and for the government, a gentleman by the name of Tom Byron, who works for the Department of Justice, will be arguing on behalf of the United States. For a short period of the defendant's arguments, a gentleman named Michael Moore will be arguing on behalf of Montana Defense Trial Lawyers Association. On my left and on your right are the plaintiff's lawyers. Andy Hubert will be arguing for the plaintiffs. The way argument works is that the plaintiffs who are challenging the statute get to go first. They have 40 minutes allocated to them and usually will reserve some for what we call rebuttal. After the plaintiff has made his argument, then the government has 30 minutes, and then the plaintiff will make whatever argument in rebuttal that he has chosen to make. On behalf of the Montana Supreme Court and the University of Montana School of Law, thank you so much for coming today. I hope you enjoy this unique opportunity to watch your state's highest court fulfill its constitutional duties. Thank you.
Good morning to everyone, and welcome to the Montana Supreme Court's annual spring oral argument here in the lovely Garden City of Montana on yet another gorgeous spring day. The court always appreciates these trips to other communities to have the opportunity to provide sort of an educational opportunity for you folks who so kindly have taken time from your very busy lives to be with us here this morning. We hope it's a valuable educational experience for you. Quite frankly, as you might imagine, the court looks forward to these road trips, as we call them, because for us it is something a little different as well. We get out of the confines of our little box of offices in Helena and get to come out to communities and see old friends and hopefully make new ones. In that regard, I want to, on the court's behalf, thank Dean Ed Eck of the law school, who could, if he chose, stop inviting us anytime he wanted. We keep hoping he won't do that. And we want to thank everyone who's helped in the arrangements for this morning, and we want to thank the faculty for hosting us last night to a quite lovely dinner in your gorgeous city. Before we get started, I'd like to introduce to you the members of the court on the off chance that you don't know all of us. And I want to say first that Justice Jim Nelson, a member of our court, was unavoidably unable to be here today, which is why we were mixing around with the chairs. He is out of state. He sends his regrets at being unable to be here. He will participate in the case, however, after he gets back to Helena and listens to the oral argument tapes from this morning. And so without further ado, on my left and your right is Justice Jim Rice. Next is Justice Brian Morris. I am Chief Justice Carla Gray. To my right is Justice John Warner, and then Justice Bill Liebhart, and on your left, Justice Pat Cotter. With those few opening remarks out of the way, this is the time and place set by our order for oral argument in our cause number 060232, Oberson and others versus the United States of America and others. Are counsel ready? Yes, Your Honor. You may proceed.
May it please the court, Chief Justice Gray, Associate Justices, Counsel. My name is Andrew Hoopert, and I represent Brian Musselman and his minor daughter Devin through their respective guardians. We're here today to discuss the constitutionality of a statute which actually is no longer in effect, but unfortunately which has a very profound effect on my client, Brian Musselman. Brian, as you know, cannot be here today because he suffered a severe brain injury over 11 years ago while snowmobiling on a duly designated Forest Service trail in the Gallatin National Forest. Brian was injured when he rode his snowmobile over an unmarked 17-foot drop in the trail and then was struck by another rider who lost control of his machine while traveling over the same ledge. Brian was rendered a cerebral spastic quadriplegic, which means he cannot walk, he cannot talk, he cannot feed himself, he cannot manage his bowel or bladder functions, and is now confined to a 24-hour care nursing facility. Although Brian is alive, he lost his life, and he left behind a young wife and a young daughter. The Musselman family filed a federal tort claim against the Forest Service for its carelessness in failing to remove or sign this hazardous drop in the trail. And a 10-day trial was held before the Honorable Donald Malloy, after which Judge Malloy issued extensive findings of fact and conclusions of law, 3 of which are not in dispute. The 17-foot ledge was a severe hazard. The Forest Service knew of the hazard, but was negligent in failing to eliminate it or sign it. The Forest Service's negligence was a proximate cause of Brian's injuries and damages. All of these findings were reviewed and affirmed by the Ninth Circuit, and the only question left is, in this long ordeal, is whether the Forest Service will be allowed to escape their liability for causing Brian Musselman's accident under the 1995 version of the Snowmobile Responsibility Statute, which leads to the first certified question. Does the gross negligence standard in the 1995 version of the Snowmobile Responsibility Statute violate equal protection? Judge Malloy reviewed this question and said, yes, it does, based primarily on this court's prior decision in Brewer. And of course, it is our position that it does indeed violate equal protection. As this court is aware, the first question in any constitutional equal protection analysis is the affected class, and we obviously have a dispute about that in this case. We start with Brewer. In Brewer, this court instructed the attorneys in this case and Judge Malloy that the affected class in these type of situations where we are dealing with these type of special interest legislation statutes is persons who participate in activities with inherent risks that are essentially impossible to eliminate. Now in Brewer, the court drew a pretty wide circle. And the court said basically we're talking about all activities that have inherent risks that are essentially impossible to eliminate. So that would include things such as hang gliding, whitewater rafting, parachuting, we could go on. I have narrowed that list, at least for purposes of this discussion, because I think it more accurately or more clearly defines what we're talking about when we are addressing these type of special interest legislative statutes. I have identified 4 statutes that are nearly identical. And in fact,
Counsel, didn't
yes.
you indicate a little bit earlier that at least your allegation was that the Forest Service should have eliminated the hill?
Yes.
So apparently that's not something that's impossible to eliminate?
Absolutely. And those findings were made. That particular issue was argued to Judge Malloy. And in fact, and it does go to another part of what we're talking about, is whether the statute was completely wiped off the books, the 1995 snowmobile statute, or whether the United States was able to maintain as a defense those protections of the statute which say the participant is still liable for the inherent risks that are essentially impossible to eliminate. And so the point being is plaintiffs proved, and the court found that yes, this was a drop in the trail which was not essentially impossible to eliminate. In fact, the Forest Service could have eliminated it, should have eliminated it, and in fact had planned to eliminate it, and then once the after the accident occurred, did put up multiple signs. So I hope that addresses the question. So we ask this court to follow Brewer and show and find that the affected class in this case is recreationists who engage in other inherently dangerous activities. And if you look at the legislative history of these statutes, I've identified, for example, the skiing statute, which was drafted in 1979, the snowmobile statute, which was patterned directly after the ski responsibility statute in 1987, the equine statute, patterned after both of them in 1993, and then the outfitting statute, which has one of the most disjointed legislative histories you'll ever want to attempt to discern. I think it was in 1981, but it's very difficult to say. Why these are...
Counsel, then,
Yes.
are you asking this court to have two classes of inherently dangerous activities, one that would include skiing and that would also include snowmobiles, but another class of inherently dangerous activities that might include skydiving, adult motocross, boxing, and so that we decide that skiing is like, or excuse me, snowmobiling is like equine horse sports, perhaps not rodeo. And then there's another class of more inherently dangerous sports, skydiving, as Justice McDonough said in Brewer, and I came up with motocross for adults with those big bikes, and then perhaps even a less inherently dangerous class of inherently dangerous activities. I don't know, rolling in the snow.
Whitewater rafting.
Well, yeah. Are you asking us to do that?
Well, I guess what I'm asking in the first place is the court to recognize that in Brewer, that's exactly what this court did do. In Brewer, this court said we are comparing skiers with other individuals who engage in inherently dangerous activities. So if the court is not going to follow that classification, that will involve overruling Brewer to an extent. But I recognize and anticipate your question, that, boy, what are we talking about, underwater bowling? I mean, what does it occur? Everything. So I have said, well, that's what Brewer said, and there are reasons for doing it, because why should one area operator, why should one industry be provided extra protections versus another industry? And that's, I think, what Brewer is saying. But I think you can more narrowly tailor the analysis to the four statutes that I have identified, which would be the equine statute, the ski statute, the snowmobile statute, and the outfitting statute. And that is because they are so similar. And they are similar in this sense. Number one, they were all enacted under the same situation of special interest legislation. These are different groups coming to the legislature and saying, we're important, we want extra protection. And so you have almost identical statutes. You have almost identical purposes. They all are there to identify the inherent risks, ask the particular participant or tell the participant, you're responsible for the inherent risks. If you get hurt as a result of inherent risk, that's your problem.
So your class doesn't necessarily encompass all inherently dangerous activities, but rather those that are legislatively regulated.
Well, again, I think the court could and should follow Brewer and can cast a wide circle and say it includes all of these other activities. But I did anticipate Justice Warner's concern that, boy, how do we put a net, how do we draw a circle around this class? There's just so many possibilities. So I think the court can fairly state and fairly rule based on those four statutes that say you're treating identical statutes, you're treating statutes that are it's in the history, they're patterned after one another. They're all there for the same reason. They all protect major industries. They all have the same purpose. The only difference in those four statutes is a standard of care. And again, as we sit here today, there is no difference between those 4 statutes with the standard of care. We're only looking retroactively back to the 1995 Snowmobile Responsibility Statute, which raised the bar above where the statutes are today.
But counsel,
Yes.
excuse me and good morning. Aren't the 4 statutes dealing with 4 different kinds of industries? Just because an industry goes to the legislature and seeks protection doesn't mean that it's locked into the same kind of standard of care or the same kind of regulatory protections that other industries would seek from the legislature, are they?
Well, the question, are they identical? Are they identical industries? Are they identical sports? Of course not. They're not. But the similarities and the purposes are so similar and are meant to accomplish the same ends that they are sufficiently similar, that this court should not say that this special interest group, you're going to get protection. This one, you're not entitled to the same level of protection. I think, for example, I would take a look, I think an appropriate way to view this also is to look at the purpose of these statutes. They all have the same purpose, and I would refer, say, to the Henry case, Henry versus State Fund. In that case, this was a case where I believe it was Tom Murphy argued that under the workers' compensation statutes, you had occupational disease claims and then you had workers' compensation claims. And that it's not fair to provide rehab benefits to work comp injuries, but not occupational disease. And this court found that those 2 classes of individuals, occupational disease, work comp, were in fact a same class. Now, I could sit here and argue and give you 5, 10 different differences between the 2. Occupational disease occurs over a period of time. The type of injuries, even though that case it was a herniated disc, that's a rare crossover. Occupational disease, you're looking at asbestos, you're looking at asbestosis, these type of things, carpal tunnel syndrome. You're looking at different mechanisms of injury. You're looking at repeated trauma versus an injury which occurs at a single moment, at a single time. There are historical reasons why these are different, but nevertheless, this court found that no, they are a similar class because they share a same purpose. And that purpose was to return the worker back to work as soon as possible. So when we're looking at these statutes, these different recreational use statutes, you're looking at identical purposes. You're looking at taking an inherently risky sport. You're asking, the purpose is to identify the risks, the inherent risks, and to identify the responsibility of the area operator. So you are looking at extremely similar type of situations, and this would be an appropriate class for that matter.
Counsel,
Yes.
how does your analysis work for us when we have to face a situation where the legislature bestows a benefit on a particular industry? For example, an industry comes to the legislature and asks for a tax break, so like the dairy industry or something like that, or asks for some sort of a subsidy from the government. Are we forced to apply the same broad-based equal protection analysis there, that they have to be treated the same as all group of other taxpayers?
Well, I think the court has addressed that in various cases, that you can treat one area of taxpayers different than another. And as far as how these 2 cases would relate, I guess I would emphasize one other point, and that would be the next point that I need to get to, and that is the standard of care. We are not dealing with purely economic legislation here. I think it is important to realize that we are dealing with a different breed of animal. And again, I would say that when you're talking about one particular type of tax-based legislation, I suspect what you're going to find is very unique, different types of legislation, as opposed here, where you have four that you can put in a box and say, okay, legislature, you have chosen these 4 industries to provide these special protections for. Here they are. You have created a classification by doing this. And therefore, we can analyze them as a class. And to get back once again to your question, again, I would refer to Brewer. That is what this court did in Brewer, in fact. We only had one single statute at that time, and the court did, in fact, say, what we're talking about is a class of people who engage in inherently risky activities. And we can, and we will, and we should compare that to other people who engage in the same type of recreational activities with inherent risks that are essentially impossible to eliminate.
So, counsel, under your reading of Brewer, and you may be correct, which doesn't necessarily mean that Brewer was correct, are you suggesting that essentially that riding a horse is as dangerous as driving a high-powered snow machine?
Well, I think you can take a look at the, excuse me,
No,
did I
go
let you
ahead.
finish? I think you have to look at the legislation. The legislation says so. Now, it doesn't give degrees. It doesn't say we're going to make snowmobiling subject to a gross negligence standard because we think, well, if you add up all the factors, it's incrementally more dangerous than, say, skiing. That never shows up. What we're talking about is a category that simply says these are all inherently dangerous sports. I mean, I certainly am not going to argue that the risks are the same, that they're identical. I mean, that'd be foolish. I can't do that. But they are sufficiently similar, and again, the statutes themselves simply, this is the legislature that created this, and they are the ones who said, we're patterning this, and you can look at the legislative language of this. Here's Mr. Melby with the legislative history on the equine statute. Mr. Melby compared horseback riding to skiing and snowmobiling. It is an activity that many people from other states and countries come to Montana to participate in.
Counsel, I'm sorry to interrupt
Yes.
you, but can you remind me in what context Mr. Melby said that?
Mr. Melby was doing that. Basically, this was part of the debate or the presentation of the equine statute and trying to say, why are we doing this? Why are we as a legislature, why are we asking you to enact this statute?
But you're still talking about purpose, and I understand you have economic and further arguments to make. But is not the whole in the logic that the legislature has the same purpose in protecting snowmobilers and, as you say, skiers, but also, as Justice McDonough would say, has the same purpose in protecting skydivers, his example, and that's why he dissented in Brewer. So the purpose is the same no matter what the degree of danger is it not?
Well, I guess I would say in one sense, yes, it is certainly the same with regard to these four statutes. Now, if you're going to throw skydiving in the mix, there is no particular purpose. The skydiving industry hasn't mustered up the lobbyists to come in and lobby for their particular industry. But the purpose, I mean, again, if the argument isn't one more dangerous than the other, or aren't there different dangers? Well, I don't know if there are different dangers.
But counsel, isn't that part of the equation here? I mean, I understand your argument about the purposes portions of the various protective statutes being substantially similar, not quite identical, but largely the same. But since we still have the 95 or 96 version of the snowmobile statute at issue in this case, don't we have to then look at the legislature's determination of how much risk there is in the further portions of the various statutes? And isn't that what's at issue here? The version of the snowmobile statute we have before us for resolution in this case is the one that uses the gross negligence standard. Are you suggesting that because they are all risky endeavors, that they all have to have the same standard? Is that what you're arguing?
Well, in a sense it is, but I think to get back to what you're asking right there, okay, don't we have to assess why the legislature decided that snowmobiling should have a higher level, or I should say a lower standard of care versus other industries? First of all, you don't have that legislative history, and to the degree that you do, it's very clear why. It's not because it's a riskier sport, it's because the industry lobbied for a higher standard to protect their pocketbooks. I mean, that's the
Counsel-
only reason they did it.
Counsel, that's what industries do, it's what lawyers groups do, it's what low-income people do at the legislature. They're entitled to go there and try to get the legislature to try to do what they would like the legislature to do. These are legislative acts.
Absolutely. But this court is in a position to look at these legislative acts and hold them to an equal protection standard, and has to say, are we simply as the panacea for all, I don't want to go to Meach just yet, but if, is this court in that position simply to say, whatever the legislature says, they get carte blanche?
Well, obviously not, Counsel.
Right.
No one in this room would make such a suggestion.
Well, I say that simply because if you read Justice Sheehy's dissent, boy, it sure sounds like that's what he was afraid of.
Well, okay.
Okay. I did want to address further your question, and I'm not remembering exactly what the question. Oh, about the different standards. Well, the other point I would make is that if you take a look at the timing of the snowmobile responsibility statute, enacted in 1987, it was patterned after the ski responsibility statute, which at that point had a standard that said there was no liability. Essentially, the standard of care was nil. So that's what they were doing. They were simply saying, well, heck, if they're entitled to that type of protection, we're going to ask for the same thing. That was prior to Brewer.
But Counsel, the language in the Skier Responsibility Act that the court struck down as unconstitutional in Brewer was not at all the same as the gross negligence language. Was it? I know you argued that it was very similar, but to me there's a substantial difference between a statute that says there's no liability at all, even for intentional acts of misconduct, and the statute before us today which says there is liability if you can meet the gross negligence standard, if you as the plaintiffs can show gross negligence. Are you really arguing that those are the same thing?
No, I don't argue that the statutes were the same thing. By no means. I mean, there certainly are different standards there. You do, as you just articulated, one standard is gross negligence, the other is all liability. What I am arguing, though, is that that's not what Brewer says. Brewer may have recognized that, but it's very clear from Brewer that the concern was the fact that ski area operators would escape any responsibility for their negligence, and that was inherently part of the statute as a result of the statutory negligence, and that was the reason. And I would say that's confirmed by Meade. If you look in Meade, when they were looking at, again, the snowmobile. Yeah, I've almost not gotten to my other arguments. I don't know if the court wants to continue down this line or whether I should jump ship here.
Why don't you go ahead with whatever time you have left, Counsel?
Okay. I'll just briefly, I think the court should take a look at Meade then, where Meade made it very clear that protecting how they ruled in Brewer was based on the fact that it absolved snowmobile ski responsibility skiers, operators, from their own negligence. And that is, and I'll give you the site, 872 P. 2nd, 782, page 787. Justice Trewiler makes it very clear that's what we were doing in Meade. I've only got 5 minutes, so this is, I'd like to touch on one other point which I think is critical. And it may be the most important point that I want to make, and that is this court should consider a heightened level of scrutiny. The one thing that separates these statutes, every one of them, from the type of legislative statutes which opposing counsel wants to argue for rational basis is safety. And there is no question that when you raise or lower a standard of care and tell an area operator that you are free from your negligent acts, you can go ahead and act carelessly and there will be no liability. When you're talking about a statute that has inherent risks, every one of these are risky activities, and you say, operator, you can do it carelessly, you are implicating individual snowmobiler safety. That's the only way these claims are brought. They're not going to be brought because, well, you should have marked a left-hand turn instead of a right. I went into the woods and got late and missed my dinner party. No, they're brought because of some negligent act by the operator which causes an injury, and safety is implicated. And I would ask the court to review, and I would disagree with the opening remarks in this sense. I think this court has recognized safety as an important right. And the case would be...
You're contending that this distinction doesn't satisfy a rational basis standard, so do we even need to get to that?
I would agree with that. I would agree that it does not implicate a rational... that this will not satisfy rational basis. Absolutely. I agree with that. But I think there is an important point to be made here with these type of statutes. They are affecting safety. And if you look at the Sims case, that case, Justice Trewiler recognized this was a med-mal case where they were requesting an IME. And one of the concerns about this was that this affected Article 2, Section 10 of the Constitution, the right to safety, health, and happiness. They were concerned that this could affect the safety and health of the individual by forcing them to go to this IME. Justice Trewiler called the right a fundamental right. I believe my 30 minutes are up.
You have 2 minutes left of your 30.
All right. And I think this is probably the most important check that this court can put on this type of legislation. Now, I understand, Chief Justice Gray, this is what special interest groups do. They go to the legislature and say, hey, protect me. And that's fine. That's what democracy is all about. But if you're going there and saying, we want to substitute profits for safety, and that's what we're talking about here. They're talking about protect us. We want our industry protected. We want our financial bottom line protected. And one way to do that is to raise this or lower the standard of care, which is going to directly affect the participant's safety. And I think the court should look very, very hard at that particular part of our argument.
Would not that expand our law tremendously? Are there any parameters that could be placed on such a ruling by this court, making anything that the legislature does that might affect the safety of a citizen a fundamental right under Article 2? I mean, how could we begin to do that with our part in the governmental scheme?
Well, I would answer that when you are talking about our Declaration of Rights and our fundamental rights, that's something this court has to do all the time. All the time, this court has to look at the fundamental rights and say, is this implicated by this particular legislation? So part of my answer is that would be no different than any other fundamental right that this court, whether it's a clean and healthy environment.
The standard of a primary seatbelt law, we would order the legislature to do that. It's proven safety. Smoking, good grief, I hate to even mention this, but firearms, I mean, it affects any possible regulation or how, isn't that what you're arguing? That it's a fundamental right and it has to be protected with strict scrutiny?
Well, at least middle-tiered scrutiny. I think it's worthy of at least more than a passive glance. I think it is worth taking a look at the safety and the health of our citizens. And I can't imagine a more fundamental or important right than the safety and health of our citizens. And if this court isn't in a position to do that, where are we? And so,
Counsel,
oh, sorry.
I know it's hard.
Came from God.
The lights are very difficult. Isn't driving a vehicle inherently risky in the real world?
Well, it depends if my wife's driving.
I doubt you scored any points with that one, Counsel.
It's certainly inherently dangerous for the other people on the street. I'm sorry. Boy, I've already lost.
I think you've made your point.
Yeah.
So doesn't the state recognize for the inherent dangerousness for activities like driving by requiring licensing and heavy regulation as compared to snowmobiling where a child or anyone can drive, or skiing or these activities? Is there government regulation in these activities we described, the equine, the snowmobiling, the skiing, that are attempt to reduce the dangerousness like we have in driving?
I'm not sure. I think I understand your question, and the answer is I'm not aware of any. I'm not aware of any particular driving statute that would come under review, because I don't think the legislature would ever enact a statute related to driving that wasn't pointed at safety. I mean, that's why we have them. They are safety regulations, so I don't see this court striking down any statutes along those lines, because that's the basis of those. And again, if safety and health is not a fundamental right, I think it is something that this court should have the ability to review these different special interest type of statutes.
Counsel, we definitely have the capability of reviewing them. There isn't any question about that.
It's a question of what standard this court will hold
Indeed
it to.
it is.
Correct. And again, my argument is safety
We
is...
understand
All
your
right.
argument. Are there
Yeah, I
other
have another
questions?
question. Counsel, I think the concern of some of the colleagues on the court regarding recognizing safety as a fundamental right is not whether the legislature will pass a law that impairs safety, but whether parties can come to the court and argue the legislature hasn't done enough. We frequently face issues where a group will come and say, well, the legislature hasn't passed a sufficiently protective Clean Air Act or sufficiently protective Clean Water Standard. It violates constitutional provisions on clean and healthful. If we have safety as this fundamental right, aren't we going to face an avalanche of lawsuits, people coming and saying, well, the legislature has to ratchet down the speed limit in this area. The legislature has to take affirmative steps to promote this right and protect this right, as opposed to simply not undermining it.
It's possible. That's possible. You will see that. And I think I can stand here and say I don't think that's a bad thing. I think there should be a standard of safety. I'm not going to play on the recent events, but safety matters. And just in the same sense that adequately funding our schools matters. Yes, you're talking about that kind of legislation where you're coming forward and saying, we're not adequately funding our schools and something needs to be done. And I think that was an appropriate thing to come to this court.
Are there further questions from members of the court? Counsel, thank you very much.
Thank you. All right, thank you.
Our Assistant United States Attorney, Victoria Francis, Mr. Robert Lane from the Montana Department of Fish, Wildlife, and Parks, and Mr. Michael Moore representing Amicus Montana Defense Trial Lawyers. With the court's permission, I'd like to share 5 minutes of our time with the Montana Defense Trial Lawyers to present argument in this court as well. We very much appreciate the opportunity to come to this court and present the position of the United States concerning these important questions certified by the Ninth Circuit Court of Appeals. In 1996, when this incident occurred, there were 2 extant and effective Montana statutes that governed the liability of the Forest Service for its maintenance of trails in the Gallatin National Forest. These trails were signed and marked for snowmobile use, but they were also, and continue today, also to be available for other uses such as cross-country skiing and dog sledding, and they are in fact used for those purposes. Under the position urged by plaintiffs today and accepted by the district court, the federal district court in this case, when a snowmobiler sues, the Forest Service is subject not to gross negligence as specified by the Montana legislature, but to ordinary negligence standards. Yet when any of those other trail users sue for precisely the same allegations of negligence or wrongful conduct, they are subject instead to the recreational use statute, which specifies wanton or willful misconduct as the only basis for liability.
But counsel, aren't those entities that are subject to that standard, aren't those individuals or entities that are not responsible, actively responsible for maintaining those trails? Isn't that a difference that's significant?
No, Justice Cotter. In fact, as I mentioned, the Forest Service here maintains the very trails at issue here in the Gallatin National Forest for multiple purposes, not just for snowmobile uses. Now, there's no dispute on the part of the government that the snowmobile area statute does cover this case, because the terms of that statute demonstrate that the landowner, the Forest Service, is a snowmobile area operator for that purpose. But it's not just a snowmobile area operator. And just as before 1987 with respect to snowmobiles, even after 1987 with respect to other gratuitous users, the Forest Service is subject to the recreational use standard. And there's no real dispute about that question. Let me turn to the equal protection analysis concerning the snowmobile statute's gross negligence provision, which is principally at issue here. Under equal protection standards, the first step this court must take is to determine whether the class specified in the statute is sufficiently similarly situated to another class to warrant any equal protection analysis at all. Snowmobiling is a unique activity with respect to the risks and the potential for liability. The particular constellation of legislative concerns and circumstances presented by snowmobiling gave rise to the snowmobile statute in 1987. Those concerns were different than, even if they were related to, the concerns that gave rise to other statutes. And the other statutes that plaintiffs rely on as comparators are themselves quite different in many respects. They single out a couple of similarities in the expressed purposes, in some statements in the legislative history. But they're different in a number of other respects. For example, although there's the similarity of identifying some of the inherent risks for each activity, each of those inherent risks is necessarily different. The inherent risks of snowmobiling, including variations in terrain, for example, and the possibility of hazards arising in the high-speed usage of those snow machines, are different from the hazards faced by a guided hunter or an outfitter, or a client of an outfitter, or a client of a horseback operation. The legislature properly takes into account all of those differences when it enacts a statute. Here, the legislature in 1987, in the snowmobile statute, set forth a gross negligence standard of care to govern liability claims by snowmobilers against snowmobile area operators.
Counsel, do you contend that prior to 1987, the Snowmobile Act, that snowmobile operators were subject to liability under the Recreational Use Act?
No, Justice Lee-Part. There were no snowmobile area operators before that term was defined in the 1987 statute. But I do contend, as I explained, that the Forest Service before 1987 and after, with respect to other users of these trails and the forest as a whole, was subject and continues to be subject to the recreational use statute. So to the Forest Service itself was subject to recreational use statute before 1987. Now, the key difference here that I'd like to emphasize.
Well, what I'm trying to get at is, if the legislature is interested in protecting the snowmobile industry as of 1987, why do they adopt a standard of care, gross negligence, which offers the snowmobile industry less protection than the recreational use standard?
It doesn't, Your Honor, and let me explain why. The entities that went before the Montana legislature and urged the adoption of the snowmobile statute in 1987 were not the Forest Service, and they were not the state landowners, public lands, that allow their use for no charge. Those entities were snowmobile clubs and snowmobile rental shops. And those entities are also within the statutory definition of snowmobile area operator. Those entities, the clubs and the rental shops, were subject to standards of ordinary care. And one of their concerns that's reflected in the legislative history, amply I should say, as pointed out in our brief and in the brief of the Fish, Wildlife, and Parks amicus, is that the unavailability of liability insurance in the mid-1980s threatened to shut down the opportunities for recreational snowmobiling in Montana. Because groomers, which were the operations done by these snowmobile clubs, these private, nonprofit, voluntary clubs, could not get liability insurance for their grooming operations. And snowmobile rental shops could not get liability insurance to rent the snowmobiles for those activities. They went to the legislature, pursuant to the right of participation guaranteed in the Montana Constitution and the right to petition for redress in the First Amendment of the U.S. Constitution. As Chief Justice Gray pointed out, there's absolutely nothing untoward about that. The legislature is peculiarly well situated to judge the merits and the needs of Montana citizens as a whole in determining whether a particular petitioner, a citizen participating in the government, has made a good case for legislation. Here, the legislature concluded that those threats that were posed to the viability of this activity in this state were sufficiently severe to warrant this change in the standard of care. That judgment is not the same, is not solely based on the inherent risk assessment. And I'd like to emphasize that plaintiff's argument that looks only to inherent risks and to the allocation of responsibilities and risks in the statute really is misdirected, because that portion of the statute is not at issue here. The question of inherent risk was litigated in the federal courts. That question has been resolved and is not presented to this court. There's no question of law there at any rate. The key question here is whether there is any justification. After all, equal protection analysis doesn't ask the legislature to do a laundry list of every purpose it has or every conceivable purpose it might have. Instead, the courts under equal protection analysis, under a rational basis test, ask, is there any plausible basis that the legislature may have had? Hardgrove makes that point. Nordlinger in the U.S. Supreme Court makes that point amply, as do many other cases under due process and equal protection jurisprudence. The key is there a plausible reason that could support the legislative judgment which must be respected? Remember, a statute comes before this court with a presumption of constitutionality. This court will indulge every basis for finding a statute constitutional before taking the extraordinary step of striking down the considered judgment of the elected representatives. So, if I may, Justice Liebhardt, to return to your question about why the standard of care was changed with respect to a couple of groups, from ordinary care to gross negligence, ordinary negligence to gross negligence, and with respect to the state and federal public landowners in the other direction, from the recreational use standard of wanton and willful misconduct to gross negligence.
Let me just preface your comments with where I'm coming from out of your brief. On page 27, you say, faced with that question in 1996, the court would plainly have concluded that the standard of the recreational use statute sprung back into effect. The recreational use statute would have applied in the same manner that it had prior to 1987.
Yes.
To me, there you're suggesting that, but for the snowmobile statute, snowmobile operators were subject to the recreational use standard.
No, let me be more precise. It's not snowmobile operators, it's the Forest Service, because it's clearly right that but for the snowmobile statute, the Forest Service is subject to the recreational use statute. And let me point to a couple of recreational use cases that this court's decided relatively recently, cases including Joby and Weinert, which demonstrate that even public entities, these were parks, a park and a dock, that maintain facilities, public property, with the purpose of these recreational activities. In other words, the fact that the Forest Service maintains these trails can't be enough to take it outside the realm of the recreational use statute, because Joby and Weinert made clear that maintaining the sledding hill and putting up a safety net at the bottom doesn't take it out of the recreational use statute. Maintaining a fishing pier and keeping that dock in place for that purpose remains subject to the recreational use statute. Sari is another excellent example where the plaintiffs in that case tried to argue that because the ski area permitted sledding on its hills after hours, therefore it wasn't within the recreational use statute. Not so, this court held. It was clearly within the plain language of that statute, just as the Forest Service, unlike, for example, any private entity that charges for access to its snowmobile trails, any snowmobile grooming operation that would otherwise be subject to ordinary negligence standards, any snowmobile rental operation that likewise would otherwise be subject to ordinary negligence standards. That's the difference, Justice Leapart, and I think it's key to emphasize the Forest Service is subject to these two statutes, and this is just a case about these particular facts.
But, counsel, isn't this statute designed to limit liability for risks over which the operator has no control? Isn't that part of the legislative history?
It's certainly part of it, Justice Cotter, but it's not the only part, and that's what I sought.
understand, but in this case, isn't there already a finding that the Forest Service did have control over the risk in question, that is, the slope of the hill and the signing of the hill? And that being so, then how would the purpose of the statute be served by limiting the liability of the Forest Service?
Let me back up for a moment to answer that question, because the basis for liability here was a failure to warn, not a failure to modify the hill. The reason for that is a peculiarity of federal law. The Federal Tort Claims Act includes a discretionary function exception, and the district court found that the discretionary function exception protects the design of the trail. Now, whether or not, and we don't know, it was possible to change the hazard in some way other than by marking it, it's not at issue. The purpose of the statute, though, as I emphasized a moment ago, includes, but is not limited to, a description of and an allocation of the inherent risks of the activity. It also includes, and this is where I emphasized the Hardgrove example and the Nordlinger example, of a court's rational basis equal protection review looking to plausible purposes, not only those expressed in the terms of the text of the legislation itself. It also includes a protection of the economic viability in 1987 as presented to the legislature at that time of these activities. And the legislature plausibly could have, and indeed the legislative history demonstrates that they likely, very likely did, conclude that that viability needed to be protected by an alteration of the standard of care. Now, Meach tells us that altering the liability under the common law or under a prior statute is in no way a constitutional infirmity, that there is nothing untoward about the legislature doing what legislatures do, which is articulating the cause of action. It's telling the courts and the parties, the litigants, what are the standards to recover in tort or otherwise. Because that itself is not protected. The equal protection analysis must recognize that these changes were within the domain of the legislative branch and should not be intruded upon carelessly, and that the district court in this case, by rejecting the snowmobile statute on a basis that I think is plainly quite insupportable, and indeed I think opposing counsel demonstrated that he doesn't try to defend it. The district court here said, gee, the snowmobile statute is just like the skier statute in Brewer. For that reason, the court said, I think the Montana Supreme Court would reject it too. Nobody defends that reasoning. The equal protection...
Counsel, the plaintiff naturally has argued to this court that in order to upset the U.S. District Court's decision and answer the question, yes, the first question, we'd have to overrule Brewer. And Brewer does say, all inherently dangerous activities. And if we're going to, how would we get through this one if we didn't overrule Brewer?
First, Justice Warner, I don't think that the holding in Brewer needs to be overruled. If the court is concerned that the equal protection analysis in Brewer depended on the conclusion that skiers were similarly situated with all those who engage in risky activities, then perhaps that, what I think must be concluded, is an overstatement of both the facts and the law, should be corrected. But there's no need to overrule the holding in Brewer, because as we pointed out, the difference in those statutes is patent. In that case, all liability was absolved. Here, the legislature took a very narrow step of altering the standard of care, something that's not unusual, in fact.
Just so that I can understand then, it's your argument that we limit Brewer to those statutes in which all liability is dispensed with. There is basically no cause of action, claim for relief under modern rules, and that if there is a way to establish liability such as gross negligence, even though it may be difficult, that we have another line of cases. Is that what you're telling us?
Actually, I think, Your Honor, that the right answer is to engage in equal protection analysis for each particular statute. And the reasoning of Brewer doesn't need to be limited, because by its own terms, it's distinguishable. And when the court in that case said, we're worried that negligence and recklessness and intentional misconduct would be outside the realm of recovery, those expressed terms by themselves distinguish the case. We don't ask that the court do anything extraordinary in that respect. I'd like to turn for a moment to the argument about the level of review, whether rational basis or some higher standard of scrutiny. Plaintiffs have argued that the inclusion in the Montana Constitution's Declaration of Rights of the word safety suffices to heighten the standard of review. But this court has made clear that a right guaranteed in that portion of the Constitution, in Article 2, warrants strict scrutiny. But even plaintiffs don't contend that strict scrutiny is warranted for anything implicating safety. I think in that respect, it shows that safety is not the kind of right this court had in mind for heightened scrutiny arising from Article 2. Secondly, safety appears in the Constitution along with health and happiness. If the plaintiffs were correct that a right exists to pursue safety, so too a right must exist to pursue happiness. That right would be unbounded and not susceptible of judicial resolution. For that reason as well, these references in the Constitution cannot be construed to impose a higher degree of scrutiny, or indeed, I should say, to impose greater constraints on the right of the legislature to enact legislation that it views appropriate for the citizens of Montana.
Counsel, I understand your differentiation between rational basis and strict scrutiny. Could you address just for a minute middle-tier scrutiny?
Certainly, Chief Justice Gray. Middle-tier scrutiny is appropriate, this court has held, where there is a self-executing provision in the Constitution other than one in the Article 2 Declaration of Rights. There's been no argument in this case that any source of the Constitution satisfies that standard. That's, I think, in Powell that the court pointed out that it would be had to be self-executing. It can't, for example, be something derived from statute, the court held. So there's no basis here other than the safety reference in Article 2 for anything but rational basis. And that passing reference to safety is not sufficient to heighten the scrutiny under this court's equal protection jurisprudence.
Counsel, turning then finally to the rational basis scrutiny, I think it's fair to say this court's rational basis analysis under equal protection has been different than the federal equal protection analysis. I would liken this court's rational basis to rational basis with bite, particularly with respect to, for example, the workers' comp cases. The court has continually said money is not a rational basis in terms of denying benefits for occupational illness versus occupational injury or those nature. How do you get past even rational basis here in this case, if we apply our standard rational basis with bite analysis?
Justice Morris, I think it's true that there are differences between this court's jurisprudence under the Equal Protection Clause and that of the federal courts, but none of those differences dictate a result in this case that would constrain the Montana legislature's discretion to adopt a different standard of review here for snowmobile area operators. And let me look at some of those examples. You mentioned Workers' Compensation Act cases. Those cases demonstrate, first of all, that it is appropriate, these economic statutes, to judge them under rational basis review, and despite the fact that one could argue they have a lot to do with safety in the workplace. It certainly can't change the outcome there. Those kinds of cases and the others that we cited in our brief demonstrate that the proper standard of equal protection is whether there is a plausible basis, purpose, for the legislature's judgment that a statute should be adopted. If there is, and if the statute is reasonably related to that purpose, this court's case law is clear. The legislature is properly within its domain to change the law. And Meach, I think, makes that point quite strongly, that it's certainly ordinary for a legislature to change the standards of liability and recovery in defining what is a lawful, what is the scope of lawful when it refers, for example, in Article 2 to the right to pursue safety, health, and happiness. What is the right
Counsel, let me interrupt you for a second. I understand. Now, you could say Meach covers an entire field of employment law. Now, I know there's differences about whether it's an employment contract or not, but here we're sort of splicing up the recreational industry. And I was struck by something you said about the snowmobiling being different than the other activities at issue because of the motors and all that involved. But why would it be rational to apply a gross negligence standard to the Forest Service for their maintenance of a snowmobile trail? And then in the summertime, we eventually get it in Montana, some of those very same trails are used for motocross or motorcycling, which I think you would agree is just as dangerous with the motors involved as snowmobiling. And then the Forest Service is subject to a negligence standard. So if
No, Justice Morris, if I may interrupt, the Forest Service is recreational use.
I'm sorry, but
and that's key, after all. That here the difference is that the Forest Service, as a public landowner, allowing uncompensated use for all of these very risky activities, no one doubts, after all, even such things as hiking, cross-country skiing, dog sledding, all of these have risks. That can't be sufficient to preclude the legislature from determining when one can recover from a landowner that's not receiving compensation. So I think that actually the example you offer, I apologize, I want to let you finish, but I think that example actually demonstrates the appropriateness of the alteration of the standards. I see that, yes.
You answered, Justice, and you said it demonstrates the appropriateness of the differences of the standards, but I lost the how. Why?
Because, Your Honor, no one doubts that the recreational use standard properly encourages the availability of land, both public and private, for these recreational uses on an uncompensated basis, and that one of the key elements of that statute is the willful and wanton misconduct standard. If it's clear that that's appropriate, and I think it is, and it's not challenged here, it must also be appropriate to lower that standard, make it easier for plaintiffs to recover, after all. I see that the 25 minutes I've asked for has expired. I'd be happy to answer any further questions the court has, but I'd like to give amicus an opportunity to speak for a few minutes. I believe that I've covered the questions posed if the court has no further questions.
The question isn't whether the legislature can define different standards under different circumstances, but rather, when they do so, has the legislature violated somebody's right to equal protection to somebody else in the same class? I mean, so doesn't that just kind of beg the question of how you define the class?
I think it does in part, Justice Liephardt, and it's key, I think, to recognize that that question of who's in the appropriate class really is a preliminary step. And if the court here recognizes that snowmobilers present a unique constellation of legislative concerns, as the legislature itself recognized in adopting this statute, the inquiry under equal protection is at an end, and there is no violation of the Constitution in this statute. Thank you, Your Honors.
Thank you, Mr. Barron. I think there's still time left for amicus.
May it please the court, counsel, my name is Michael Moore. I'm here today on behalf of a friend of the court. As the court knows, on behalf of the Montana Defense Trial Lawyers, I filed a brief in this court, and it is from that perspective that I would like to offer the court a few thoughts. Recreational statutes, and we've talked about several of them here today, present a legislative statement of public policy which is designed primarily to encourage recreation. It does so in a variety of ways, by making recreation more available, by making it possible for providers to make recreation available, and by giving participants who happen to be the citizens of Montana and our guests choices and opportunities to participate. And similarly, in a very practical way, the more choices that our citizens have and that our guests have to participate in recreation, the more freedom they have in our environment. So this type of legislation encourages the use of Montana's multiple and beautiful natural resources, and it provides an opportunity for those participants to choose how they participate. And I believe that is the grounding of all of these types of statutes.
But counsel, the snowmobile operation or the snowmobile industry has not imploded since 1999 when the standard went to negligence. I mean, what I'm saying is are you arguing that we have to have these lesser standards of care imposed upon certain industries in order for them to survive?
I'm not arguing that precisely. What I'm saying is that it's appropriate for the Montana legislature, when enacting these statutes, to take those factors into consideration, to create a liability environment in which participation is encouraged and in which providers are encouraged to provide those opportunities for participation. And empirical analyses or precise delineations of what would make this possible and that possible is not required, in my view, under the appropriate standard of review of this particular type of legislation. It is enough that the Montana legislature believes, when those people come to testify at the legislature, that those are real concerns. And so I'm not arguing that it's absolutely essential, but I'm saying that it is an appropriate legislative purpose.
Counsel, I wanted to ask you about, in Mr. Hubert, in response to a question, distinguished situations where the legislature might grant a tax benefit to a particular industry versus the type of statutes at issue here, and he said the distinction was that these statutes involve questions of safety and therefore should be subject to a higher or more strict standard of review than the tax break industry may receive from the legislature. How would you respond to that?
Justice Morris, I would disagree with that characterization. In the tool chest of the legislature is the opportunity to address different types of opportunities differently and at different times. In the same way, it addresses different taxpayers differently and at different times. And I think if you look at the history of these statutes, despite the effort to bind together equine and skiing and snowmobiling, you will see that they were enacted at different times by different groups coming to the legislature. I think that is part of that gristmill in Helena that occurs every 2 years, where the product of that is legislation that's specific to groups. And I don't see anything outside appropriate legislative function in taking these issues on one at a time. And I think the court's law on that is very clear, that that's permissible. that I think it's the Geis case, the Montana Irrigation District case, the Missoula Irrigation District case.
I have one more question, that's right. Council, I wanted to, you talked about in your opening remarks about expanding freedom for allowing people to make choices, engage in that. And I guess I see that as a bit of a slippery slope, though. Wouldn't it expand freedom to remove regulations on driving, remove regulations on a number of activities that the government has chosen to step in? Back when we had the speed limit issue, but the legislature has chosen to step in and regulate those because of the dangerousness involved. The legislature has not yet chosen to step into these other industries because there's a standard of care involved. Now, aren't we running the risk of the legislature saying, well, we're going to eventually have to come in and regulate these industries if we're not allowing people a protection that they may not know because there's dangerousness in these activities, they're not fully informed of the dangers?
That's certainly a possibility, but I think you've hit the nail on the head here. That is a legislative function. That is best left to the legislature and our elected representatives to make that public policy determination of the environments within which we need to operate at different levels, either highly regulated, with relaxed standards of care, with greater standard of care. That is a uniquely legislative function, in my view. And so if the legislature were to make a determination, for instance, that if they have a certain standard of care and out there people are just doing crazy, wild things in the environment recreationally, that they could step in and make an effort to regulate that more precisely. But that effort hasn't been made. And again, that's my whole point. That is a legislative function, and here it was properly exercised.
Unless it violates equal protection.
That's correct. And the rational basis we're arguing, one of them is the making of these opportunities available by creating an environment within which providers are willing to provide the opportunity and within which participants have choice and freedom.
Are there other questions from the court for Mr. Moore? Because otherwise I believe his time is up.
Thank you very much.
Seeing none, as they say at the legislature, thank you very much. Council rebuttal.
Thank you, Your Honor. I'll start with what's most fresh. There's a lot of talk about the legislative prerogative to enact these statutes if that's what indeed they felt was appropriate for the time. And I just want to emphasize Justice Leapart's response. Yes, nobody argues that there isn't a legislative function to come in and enact statutes, and whether it's regardless of one special interest group or another coming in, that's what the legislature does. But Meach, and that's implied in all of this, it's cited 9 times in the United States brief, does not say, or it shouldn't say, that it's carte blanche, and that this court's only responsibility is to make sure the lights are on in the courthouse, that there's sufficient water on the tables, and that everyone can get in who actually has a cause of action left to them. You have to remember the second part of Meach was an equal protection analysis. And if we're talking about, say, Brewer, we're trying to make a distinction, that counsel is trying to make a distinction of the statutes and saying, well, that one's different because it's all liability. Here we have a gross negligence standard. Even if we were to say that was a defining factor in Brewer, which it was not, and again, I emphasize read Justice Treeweiler's opinion in Mead to answer that question. But even if it was, we're still looking at an equal protection analysis. We are still looking at a different treatment to a different class of recreationists, gross negligence versus negligence. So the fact that there may be a little difference between the two different statutes, a difference between the standards of care, you're still looking at an equal protection analysis. The analysis still flows. There is still unequal protection between the statutes. Brief discussion of the recreational use statute. Once again, I heard several times that we didn't contest that the recreational use statute applied to the Forest Service prior to this. That's even more creative than the argument in the first place that somehow the recreational use statute was enacted and applied to this situation. It did not. The recreational use statute was enacted to encourage landowners to open their gates and let people come on and recreate. There was no duty for the landowner, no duties imposed to maintain a trail system, no groomed trail system at all. It was not intended to attract riders. It was intended to encourage landowners to let their gates be open. There was no particular industry behind that legislation. This was simply a type of legislation intended to allow people on to private land. That is significantly different than the snowmobile responsibility statute. That statute is intended to promote the snowmobile industry. It creates a new class, a statutory definition called a snowmobile area operator. That is something that did not exist prior to its enactment. So when council argues that, well, if you knock out the standard of care, what they're really arguing is you have to throw the whole baby out with the bathwater. Suddenly, we now no longer have this statutory creation. We no longer have these statutory duties which define a snowmobile area operator. That is a whole different situation. So it's akin to arguing that if you have a square peg, it doesn't fit into the round hole. The snowmobile area operator is not subject to the recreational use statute because the landowner doesn't have these affirmative responsibilities to maintain a trail system. And what the argument is, well, if you take away, and this is no longer a square peg, will this square peg now fit into the round hole? It's still a square peg. They still had the statutory responsibilities. They were still a snowmobile area operator. This particular classification, legislative classification and definition did not exist prior to the enactment of the snowmobile responsibility statute and was not subject to the recreational use statute.
Just as an aside, Counsel, you would also have to eliminate the comparative negligence part of the 1996 snowmobile, or 1995 snowmobile statute.
Correct, and
That'd have to go too. There'd be two parts, the gross negligence and the comparative.
It would, and the reason you don't see that before us today is it was never argued below, it was conceded below by the United States. Even if this court does apply a rational basis, once again, we can immediately jump to Brewer and say, there's your answer, or we can analyze it as we should on its own merits. The purpose of the snowmobile responsibility statute is well set forth. It is to identify the inherent risks and to identify the responsibility of the participants. And then Brewer adds a third to protect the industry from frivolous lawsuits over which the operator, for risks over which the operator has no control. Those are the purposes. So take those purposes and now take a gross negligence standard. How does a gross negligence standard further those purposes? It does not. It does not define the risks of the sport, unless you're going to say, one of the risks is this operator over here might be asleep at the wheel and injure you because of their carelessness, which is an absurd reading. Second of all, does it further identify the responsibility of the snowmobile area operator? No, a snowmobile area operator is someone who has statutorily defined responsibilities to maintain the snowmobile trails.
Counsel, I'm sorry to interrupt you. Your time is up, so could you try and wrap up real quickly?
All right. It's been 11 years. We've been at this a long time, and we've been through multiple states, and it's been a well-argued, a well-tried case. I have all the respect in the world for counsel that I have come to meet and appreciate throughout this, and once again, I just want to thank the court for its time in we hope, the final step in this long, arduous process. Thank you very much.
Thank you very much. Thank you to counsel who have argued or otherwise participated. Folks, we want to thank you again for taking time out of your lives that are every bit as busy as all the rest of ours, to be here with us this morning to see your Supreme Court in action, and also, and importantly, to see some really fine lawyers present oral arguments to your state's highest court. And with that, we will take our cause number 060232 under advisement.